Assalamu alaikum. My name is Bilal Sain Khan and I'm your host on Just Law on Ikra TV. As our regular viewers are aware, at Just Law we deal with aspects of criminal law and other English law. This is a live call show, and at the bottom of your screen there will be a telephone number and you are free to call in, ask any questions. And by virtue of the fact that we're a live call show, there will be certain questions that we may not be able to answer in great detail, specific detail. For argument's sake, if you are asking regarding your own particular case, we may need to look into some documents, we may need to speak to you personally, and because of confidentiality reasons we may not be able to go into full detail. And in those circumstances we ask you to contact the contact room and provide your name, telephone number and details with the question, and then what we'll do is we will contact you back within the next couple of days. I personally will contact you back and I will answer the question in detail. On live show, what we'll do is we'll answer the questions generally, and if there's any question that I cannot answer, then I'll make a note of that question and I will come back to you with the answer if you provided your details with the control room. Alternatively, the following week, what I'll do is I'll answer the question that you've asked. Now, over the last couple of weeks, we've been dealing with rights and entitlements at a police station, and we've also discussed about the changes of the law in relation to Brexit. And a question did come last week regarding settlement visas under the European scheme, and after an absence of how long will that visa be cancelled, nullified? And the answer to that question is a period of 3 years. Now, under the European settlement route, if you've lived within the United Kingdom for a period of 5 years prior to 31st of December 2020, then you will get settlement status, and which basically means that you're entitled to live here. However, if you leave the United Kingdom for a period of 3 years, then that visa will be cancelled and you will have to reapply. Now, there was a confusion, and the caller was saying that some people are saying 2 years, some are saying 3. The reason there is that confusion is if you have indefinite leave to remain from another country and then the rules are different, then it's 2 years. So if you have an absence longer than 2 years, then that visa is cancelled. However, for the European settlement visas is a period of 3 years. So for argument's sake, you was to go back to France or Germany for a period of 1.5 years or 2 years, as long as it's less than 3 years, then your settlement status will not be cancelled. As long as you come back into the country, into England, and start living and residing as your main residence, then that will be acceptable. However, if you stay for longer than 3 years, then that settlement visa will be cancelled and you will have to reapply. And if we're using an example for a Pakistani indefinite leave to remain visa, then same rules apply. However, the term is 2 years. So for European settlement, 3 years. For other visas, it's 2 years. And that's the absence out of the country. Now that we've answered that question, what I was thinking of doing is for today is continuing the topic of custody, and our viewers are aware we've already talked about your rights and entitlements inside custody and identification procedures that will take place whilst you're in custody, and also how long the police are entitled to keep a person inside custody. And thereafter, the decision now, I would like to talk with our viewers what decision the police will make within that time frame that you are in custody, and then what will happen thereafter. Now, when you are suspected of an offence and you are arrested, and then under normal circumstances within 24 hours the police will have to make a decision as to what action is to be taken against you. The action to be taken against you could be the following. Number one, you can be charged for the offence. Number 2, you can be released with no further action being taken against you. So the case has been dropped against you, the case has been charged. The third is you could be released under investigation, which basically means that you've been released from the police custody, you've not been given a return date to come back to the police station, which means that the case has not been dropped against you. The police are still investigating the case, and if they find any further evidence against you regarding the offence, then they'll invite you to the police station to ask you to come down and to speak to you about the fresh evidence that they find. The other option is to release you on bail, and if they release you on bail, then that's for a maximum initially of 28 days. Now what they'll do under those circumstances is they may release you on unconditional bail, which means that you have no conditions apart from returning back to the police station on the particular day and time, which is usually 28 days. And within that time frame, the police will conduct further investigations, and this option is used under those circumstances where the police believe that they will be able to gather further evidence or further inquiries within the 28-day frame, and then make a decision as to whether they're going to charge or exonerate the person from the allegation. Now, that's unconditional bail. The police may also impose at that stage conditional bail. Now, conditional bail is where they're asking you not to do certain things. One of that may be not to go within 100 meters of a particular address, not to contact the complainant directly or indirectly. Thirdly, maybe a curfew, so you're not allowed to go outside your house between a particular time. Another one may be not to be the driver of a motor vehicle, etc., etc. Now, these conditions have to be necessary and proportionate to the risk that the police believe that there is in your case. So they have to believe that if they release you on unconditional bail, then there may be a risk that you'll commit further offences, you may interfere with witnesses, or you may abscond. And for those reasons, they'll tie you with a list of conditions. Now, this is pre-charge bail. Now, pre-charge bail is different to bail when you've been charged for an offence. And when you've been charged with the offence, it'll be different. One will be police bail, which you've been granted by the police, and the second will be court bail once your case has appeared before the courts, and then at that stage the courts have assessed your case, your bail will be re-looked at, and you'll be given bail conditions again. Now, the question arises at the police station, if you are given bail conditions, do you have to abide by those conditions, or can you make representations against those conditions? Because a lot of people believe that if they are given certain conditions, then that's the end. They have to stick by those conditions, and there's no two ways about it. And after 28 days, they'll have to go back. And then after the 28 days, they may even get rebailed. The superintendent at that stage will look at the case after 28 days and may even extend your bail for another period of 2 months, so a maximum of 3 months. Now, to answer that question, it's your right and your entitlement to challenge those bail conditions, and you can make representations to the police station. Initially, you'll speak to the officer in charge of the investigation and make representations regarding the need of having those bail conditions in place. They have to be necessary and proportionate to allay any risk that the prosecution or the police may have in your case. Now, it's important for the police to substantiate those concerns. It's not good for them just to say that, look, we believe that you're going to commit another offence, so for that reason we want you to surrender your passport, and we want you to sign on to the police station every single day, and we need you to stay inside your house between 7 p.m. and 7 a.m. Now, if you've never been in trouble before, and if there is reason to say that you will not commit further offences, then you can make those representations. Now, the officer in charge of the investigation is the person who probably wanted those conditions to be in place. So 9 out of 10 times, the officer in charge of the investigation will say, nope, I'm satisfied that those conditions are necessary and proportionate, and I'm going to leave them in place. Now, what do you do then? You go to the custody sergeant and you speak to the sergeant and you make representations to the sergeant to say that I'm not satisfied that the bail conditions are being imposed lawfully, and in the circumstances these are the representations, and your solicitor should make those representations on your behalf and argue those conditions. Now, the sergeant has a decision whether he chooses to accept the representations made by you or to decline those, and then at that stage you can go to the inspector or the superintendent and make further representations to them. Alternatively, what you can do is you can lodge an application to the magistrates court, and what you do there is you're saying to the magistrates that the police have erred in their decision, they've made a wrong decision, and they've imposed these conditions which we believe are draconian and we believe should not be in place. And then what the magistrates will do is the magistrates will consider each and every bail condition and then have a look at the reason why the prosecution are saying that the condition should be in place and why the police have put them in place, and to see the reason why they should not be in place. A majority of the times, whenever I have made such applications on behalf of my clients, we've had the bail conditions relaxed on behalf of our client. Now, the magistrates will independently look at the case, they'll look at the background of yourself or the clients, and they'll have a look and see whether there are significant grounds to believe that there is a risk that the person will abscond, commit further offences, interfere with witnesses, etc. And then if the prosecution cannot satisfy the magistrates, or the police at that stage cannot satisfy the magistrates as why there is the necessity to have these bail conditions imposed, then the magistrates can cancel those conditions, they can remove them in their entirety, they can amend those conditions, or what they may do is they may impose other conditions. So it's always important to note that if you are given conditions, the conditions cannot just be willy-nilly given to you. They always have to be there for a reason. You can challenge those conditions even if it's pre-charge bail, and then there is avenues that your solicitor will be able to remove those bail conditions in place. Now, the other question is, what if you are charged with the offence? And sometimes if you are charged, you may be remanded for the offence if the police believe that there's significant grounds to believe that you will commit further offences, interfere with witnesses, abscond, etc. Then the police can also make a request to the prosecution to say that we believe that this person is going to be a risk if we grant him bail, and we believe that he should be remanded into custody. Remanded into custody means that the person should spend the rest of his time until the conclusion of his case in jail, whichever the nearest jail is to that person. Now, under those circumstances, an application for bail will be made on your behalf by your solicitor, and a full application will be heard at the magistrates. Now, I'm going to go into further detail regarding this, but before I do so, regarding post-charge bail, we're going to go for a short break, and after the short break I will discuss everything with you.